Case law is truly a beautiful thing in Florida family and divorce law. If you are somebody's attorney, case law will give you practice, procedure, guidance, a foundation for arguing something. If nothing else, at least by way of analogy or by way of constructing some alternative argument that might not yet exist but is applicable to your case. I want to direct you to the newest 4th District Court of Appeals decision as of April 29th, 2026, called Weingar versus Weingar. If I were a cynic, I might say vinegar versus vinegar. I truly do not know how they pronounce their names. Nonetheless, this case gives us guidance on a couple of fascinating things. One, it gives us guidance about the marital asset potential of somebody's marital business and how it may or may not be valued and according to what. This is where experts come into play. Experts are an expensive and yet inarguably incredible tool to have in your toolbox at trial in a family law case. And the other component of that case that I find fascinating of Winiger versus Winiger is that if you have premarital inheritance interests and then you spend it on something in the course of a marriage and then replenish those monies, you might not have in fact changed the character and created a commingling for the court to consider that to be marital property. There may be a way, there may be a path to having premarital monies spent during the course of the marriage maintain their character as non-marital inheritance, as premarital property, not subject to equitable distribution. For now, I would like to focus on a husband's law practice and whether or not the trial court valued it properly and whether or not the District Court of Appeals made the right decision in response to that. Here we go. Both husband and wife argue that the trial court mistakenly valued husband's law practice at $140,000. Believe it or not, $140,000 for a law practice is probably very, very good. That is a successful small law firm. An expert on behalf of the wife testified that the practice should have been valued at 263. Husband argued with his own evidence and his own perspective, of course, the polar opposite, that his law practice is worth absolutely nothing. Absolute zero. The trial court decided to do, and I've never heard of this version of the phrase before, baby splitting. The trial court decided at a number in between for purposes of equity and fairness. This is what the District Court of Appeals called Solomonic wisdom. Still, as the court said, baby splitting must be supported by competent, substantial evidence. A trial court may have broad discretion in valuing something like a retirement account, but resorting to estimations is not appropriate. We need actual evidence. Splitting the difference between two values is not competent and substantial evidence. Florida law prohibits valuation based upon instinct, based upon averaging two polar opposite numbers. There has to be competent, substantial evidence, and the date of valuation has to make sense. Therefore, on remand, which means if you've heard the podcast before, you know this. If you have not and you do not have a legal background, remand means somebody at a trial court level created a trial order after the hearing, final hearing trial, and that was disagreed upon. Somebody appealed the case to the District Court of Appeals for the 4th District in Florida. The 4th District decided that the trial court's decision was erroneous, reversible error, and therefore it remanded the case. In other words, pushed it back to the trial court level for the trial court to enter specific findings that a law practice, if it is part of a divorce, has to be valued by competent, substantial evidence with a quote, clear valuation date. That is the correct decision. While the expert witness probably didn't seem so expert on the stand, or else the court likely would have been convinced at the trial court level, the fact that the husband wanted his law practice to be valued at absolute zero, and the fact that the expert witness wanted the law practice to be valued as if every month is a gold mine and there are no twists and turns and no roller coasters and no advertising costs and all of these different things, I really think that the trial court's valuation was probably fair. But because they arrived at it in the wrong manner, it had to be reversed. And the trial court had to eat a little bit of crow, which means that in the future, that trial court judge will have to be more careful. And even if they ascribe a fair value to something, they must do so in a certain manner, or else they are likely to be appealed and overturned. Of course, provided the person appealing has 10, 20, 30, 40, $50,000 for that appeal. And finally, the third part that I find really interesting here is this. Husband and wife, I'm sorry, not the third part. What am I saying here? This is, in fact, the brokerage account. My mistake. Husband opened a Wells Fargo brokerage account prior to the marriage, premarital, non marital, separate property. During the marriage, husband used his Wells Fargo brokerage account as collateral to obtain a loan. The loan proceeds paid marital expenses. Husband then paid off the loan using funds from the parties' marital Bank of America account, and he deposited those funds into his Wells Fargo brokerage account, the original non marital account. The wife argued that that was commingling. The trial court held that the brokerage account started as non marital, but became a marital asset when marital monies repaid the loan. However, the District Court of Appeals believed otherwise. An asset acquired prior to marriage is by definition non marital. Non marital assets may lose their non marital character when they've been commingled with marital assets. Money is fungible, therefore, fungibility equals commingling equals losing separate character. However, pledging an account as collateral does not convert it into marital property. The former wife did not establish that the husband's property had been transformed just because he obtained a line of credit. Ladies and gentlemen, I disagree with the District Court of Appeals' decision. However, this provides guidance on where there may be circuit splits in other cases that are a little bit older, since this is perhaps the newest on the issue, may have somewhat of a different result. This is, for all intents and purposes, the primary law of the land that we must prove or disprove and must adhere to when litigating these things and advising our clients. Thanks for listening.